A federal judge just did what OpenAI feared most. The judge ordered them to court to reveal secrets they never wanted public. Suddenly, Elon Musk's $38 million claim and the very promise to keep AI for humanity are on trial. If even half the hidden evidence is real, every lab from Google to Meta could be forced to rethink everything. Someone is lying, and this verdict will decide the rules for everyone. Inside every major artificial intelligence lab, lawyers and founders are watching the courtroom drama unfold, not because they care about Elon Musk's $38 million, but because of what is at risk for the entire industry. At the heart of this trial lies a question that could rewrite the rules for every company chasing artificial intelligence. Are mission statements and public benefit promises just marketing, or do they carry the weight of a binding contract? If a jury decides that OpenAI's founding pledge to benefit humanity is legally enforceable, every artificial intelligence company with a nonprofit charter or public mission could face new scrutiny from regulators, investors, and the courts themselves. The debate is no longer about personalities. It is about whether the promises that attract billions in donations and talent actually lock a company into a path, or if those words can be set aside when it is time to chase profit. Charitable trust law, usually reserved for hospitals or universities, is suddenly being tested against the world's most advanced technology labs. In the past, courts have forced organizations to return millions when donor intent was ignored, but never at the scale or speed of the modern artificial intelligence race. If OpenAI's mission is ruled binding, it could mean that every assurance made to donors, employees, or the public, no matter how aspirational, becomes a legal obligation. Investors like Microsoft, who poured in $13 billion expecting returns, would find themselves answering to the same standards as a charity. And for the labs, building the next generation of super-intelligent artificial intelligence, the verdict will decide whether they answer to their founding ideals or to the bottom line. In December 2015, a group of Silicon Valley's most ambitious minds gathered to launch OpenAI as a nonprofit. Sam Altman, Greg Brockman, and Ilya Sutskever set out to build artificial general intelligence that would serve all of humanity, not just shareholders. Elon Musk, already known for his bets on electric cars and rockets, became both a co-chair and the lab's most prominent early backer. Through an intermediary, Musk contributed about $38 million, roughly 60% of the lab's initial seed money. That funding was not just a check, it was a statement of faith in the promise that OpenAI would remain non-profit, keep its research open, and never let any single company control artificial general intelligence. The founding documents filed in Delaware spelled out a mission that tied every dollar to public benefit. Any profits, if there were any, would be funneled back into research for the good of all. The bylaws even dictated that if the nonprofit ever dissolved, its assets had to go to another charity, not to founders or donors. Public announcements in the original website described OpenAI as an open nonprofit research company, inviting others to join a mission that would never chase private gain. Musk's support, both financial and reputational, helped attract top researchers and gave the project instant credibility in the artificial intelligence world. But the idealism that brought the founders together soon ran into friction. By 2017, internal diary entries show Greg Brockman wrestling with doubts. He warned that promising a nonprofit path, then switching to a for-profit model, would be a lie. Tensions grew as Musk pushed for more control, proposing either a merger with Tesla or a leadership shakeup that would put him in charge. The board refused. In February 2018, Musk resigned, citing conflicts with Tesla's own artificial intelligence work. The split left behind a trail of emails, diary notes, and board minutes, each one now a potential piece of evidence in a courtroom fight over what was actually promised and to whom. In early 2019, OpenAI's leadership approved a dramatic overhaul. The nonprofit structure that once defined the organization gave way to a new entity, a for-profit limited partnership called OpenAI LP. This was not a quiet change. It was a calculated move designed to unlock the billions needed to keep pace with tech giants like Google. The new hybrid model promised a cap on profits, no windfall for investors, just enough to attract the scale of funding advanced artificial intelligence demanded. But the details mattered. Microsoft arrived first, investing $1 billion that year, with future commitments swelling their stake to more than $13 billion by 2025. In exchange, Microsoft secured preferred access to OpenAI's technology and a seat at the governance table. Emails and internal notes from the period reveal a leadership team wrestling with the trade-offs. Greg Brockman's private diary, later unsealed by the court, captured the tension, noting that it all comes down to the money. In another entry, he questioned whether shifting to a for-profit model so soon after promising donors a nonprofit mission would be a lie. These documents show a group of founders not just debating strategy, but the ethics of their own narrative. OpenAI's defense rests on the argument that this structure was necessary. They point to the skyrocketing costs of artificial intelligence research and say the capped profit model still serves the original mission. The nonprofit parent retained a 26% stake after a 2025 restructuring, giving it ongoing oversight. Yet for critics, the influx of billions from Microsoft and the new incentives for leadership raised doubts about whether public benefit could truly survive when profit entered the equation. On January 8, 2026, U.S. District Judge Yvonne Gonzalez-Rogers issued the order OpenAI dreaded most. Their motion to dismiss the lawsuit was denied. The judge wrote that there is evidence suggesting OpenAI's leaders made assurances that its original nonprofit structure would be maintained. That, she said, is enough for a jury to decide, not a judge behind closed doors. This ruling means every disputed promise, every assurance made to Elon Musk about OpenAI's mission, will be pulled into the light. The trial is now set for April 27, 2026. Jury selection begins that Monday, and the case is expected to last up to 4 weeks. The courtroom will hear arguments over 3 surviving claims: fraud, unfair competition, and unjust enrichment. Elon Musk alleges he gave $38 million based on promises of a permanent nonprofit and open research for humanity's benefit. He says OpenAI leaders misrepresented their intentions, lured him and other donors, and then built a for-profit empire with Microsoft's billions. OpenAI insists Musk knew about the for-profit plans, left because he could not take control, and is now using the courts to settle a business score. The judge's decision is more than a procedural setback. It triggers the full force of discovery, forcing both sides to surrender internal emails, board minutes, and founding documents for the years Musk's funding and reputation helped build the organization. Every word in those records, every hint of a pivot or a promise, becomes potential evidence. Depositions are expected from Sam Altman, Greg Brockman, and Elon Musk. For OpenAI, this means the risk of embarrassment, contradiction, or worse, smoking gun proof that could sway a jury. For Musk, it is a chance to prove his warnings about mission betrayal were not just sour grapes. The courtroom is set. Now, the hunt for the truth begins. Inside a locked evidence room, more than 100 documents wait to be dissected. Investigators will scrutinize Greg Brockman's private diary entries from late 2017, including a line that reads, "If 3 months later we are doing B Corp, then it was a lie." Board minutes and internal emails from 2015 through 2019 are now fair game, including confidential exchanges about the Microsoft partnership and early drafts of the founding agreement. Communications between Sam Altman Ilya Sutskever and Elon Musk will be compared line by line, searching for proof of concealed plans or broken promises. Musk's own emails and donor correspondence will be examined for any sign he knew about a for-profit pivot. Every deposition, including Sam Altman, Greg Brockman, and Elon Musk, will dig into what was said, what was written, and what was kept off the record. The next breakthrough could come from a single redacted sentence or a forgotten memo waiting to tip the scales. A verdict in this case will ripple far beyond the walls of a single courtroom. If the jury sides with Musk, OpenAI could be forced to pay billions in damages, overhaul its entire governance, or even unwind its for-profit structure. Microsoft's $13 billion stake may face new restrictions, and every AI lab with a public mission could suddenly be bound by promises once thought to be just aspirational. On the other hand, if OpenAI prevails, mission statements may be treated as flexible, guiding values, not legal contracts. That would give AI companies and their investors the freedom to pivot as markets demand, but at the cost of public trust. The outcome will define whether the world's most powerful technology is kept in check by founding ideals or by those who control the money. Every AI company now faces a reckoning. Are mission promises enforceable or just marketing? As discovery unfolds and the jury decides, billions ride on the answer. The future of artificial intelligence, and who we trust to shape it, may hinge on what gets revealed in that courtroom. What matters more, intent or outcome?